Okay, hey everyone. I'm William Large. I'm the president of the Florida Justice Reform Institute. What we advocate for is we are trying to fix our lawsuit abuse system, and we're going to talk today about something called transparency in damages. And here's how this particular area works, and I want to make sure that you all understand this. First off, I'm going to give you a real-world example of how a verdict form works. So what you see behind me is what a real verdict form looks like. First, there'll be, was there any negligence in this particular case? If there was, the jury will hit check. And then usually there's not just one defendant sued, there's several defendants sued. So in this particular case, on this verdict form, I put in defendant 1, 2, 3 and defendant XYZ company. From there, there's percentages of fault that a jury's asked to look at. Next, a jury is asked to look at what the past medicals were and a series of other lines of damages. So look at line 5 there. You'll see that the past medicals are $90,000. When the past medicals are a certain number, like $90,000, it tends to affect the overall verdict in the entire case. In South Florida, cases tend to be about 4 times past medicals. Orlando North, they tend to be 3 times past medicals. So the bigger that line, that $90,000 line is, the overall verdict should be bigger, because you see line 6 there, that is future medicals. The bigger the past medicals are, the bigger futures will be, and all the other lines in there, pain and suffering, the total amount of damages for any lost earnings, they tend to be a multiple of past damages. So the plaintiff's bar has a real incentive to increase the past medicals. Now, what I'm going to show you are real examples from real cases in Florida. What they are doing is they're using something called a letter of protection, which is a promise to pay a treating physician in the future when the verdict or settlement comes in. Now, a very pernicious aspect of Florida law comes about because of a case called Worley versus YMCA. So if someone is injured in Florida, the Mr. Plaintiff's attorney will refer that injured person to a treating physician that they already have a relationship with. They will say, Paul Plaintiff, I know you have insurance, healthcare insurance to cover this claim. I do not want you to use it. I know you already have a doctor. Do not want you to see them. Instead, I want you to see my doctor. And good news for you is they're going to treat you under a letter of protection, so you don't have to pay today. So in this example right here, the letter of protection is $81,415, okay? I expect, therefore, based on that first example I showed you, I expect this verdict to hit at around $320,000 in South Florida if the jury believes liability. What happened in this case is the doctor sold that letter of protection, which is like an IOU, so it has value. It's like a promissory note. He sold it for $18,000. I then had my own coding expert say, what would this have cost under Medicaid, Medicare, workers' comp, and usual and customary? This particular case was a Medicare patient. You can see that had she used those charges, it would have been $7,721. So what the plaintiff's attorney has effectively done is increased the past medicals from $7,000 to $81,000. Now, what is the true value of that treatment? There's potential options. One option is, what did the doctor sell that LOP for? It's $18,000. That is not being allowed to be introduced into evidence right now, that that doctor sold the LOP for $18,000. Another potential example is, what are the other numbers that would have been charged in the relevant geographic area? Or maybe another example is, what would the number have been had she used Medicare in this particular case? Here's another example, real case. The letter of protection, the promise to pay the doctor in the future, was $105,175. The doctor immediately sells the LOP for $23,000. Again, this was a Medicare patient. What the jury's going to see is the $105,000. I'm expecting, therefore, that verdict to kind of land in South Florida at about $420,000, but you can see what other numbers are out there. Again, another number, and this one is another real example. Interesting, the letter of protection was $211,000, okay? The LOP was given away for free, and what happens is the LOPs are invariably purchased by factoring companies. All the factoring companies that I have researched are owned by other personal injury attorneys who've seen this as a very profitable business model. Sometimes they will give away a LOP for free to make up for another case where the verdict may have been zero. So in this case, the LOP was given away for free, and this was a person who did have health insurance, and had they used their insurance, which they didn't, it would have been approximately $66,000. So I use that to show you what happens when there is a past unpaid medical. And when I say unpaid, the letter of protection theoretically still has a face value of the original LOP. So that is something that remains unpaid. And why do they do that? Okay, number one is to increase the value of the overall case, but secondly is to get around something called the set-off rule. And I'm going to show you how that works as well. Now, how does it work for past paid medicals? Okay, this here is, again, real cases, and this is an example of where the healthcare provider in question did not use an LOP. But this is also how there can be an inflated example here. So here, this is an example of a bilateral lumbar radiofrequency ablation. So someone's in a car accident, they're going to put a needle on you, it's going to send out radio waves, it's supposedly going to heal you, okay? This particular case, the bilateral lumbar radiofrequency ablation, okay, was done for about $20,188, okay? That's the number the jury's going to see. But they accepted $1,325, which is that red bar graph there, okay? That's the amount that they accepted. What's going to happen when the jury sees that bigger number? I believe the overall verdict is going to be a multiple of 4 times that. Now, as is often the case, it's not about one medical procedure. It's about a series of medical procedures. So this is just one medical procedure picked from a real case. Here again is a case with a arthroscopy left wrist with platelet-rich plasma injection. The billed amount comes in at approximately $21,136. They actually accepted $4,000 as payment. So the jury's going to see that bigger number. They're not going to see the accepted amount, and that's going to tend to affect the overall verdict. Here's another one. So often with all these fact patterns, not only is the surgical procedure part of the bill, the anesthesia services are part of the bill. So in this one, the anesthesia services were $5,204. That's the number the jury's going to see. Okay. The accepted amount was in this particular case $800. Now, here's the nuance that why this is so important. there is something in Florida law called a set-off, and this is how the trial bar tries to add confusion to this and try and say that there's not a problem, even though there is. So if you go back to that original example that I gave you, where the past medicals were $90,000, and therefore the overall verdict would have been $360,000, I've created here a motion for set-off based on that verdict. What happens in Florida law for the paid amounts, and remember the first examples I gave you with green, those were past unpaid amounts. The examples I gave you in blue, those are past paid amounts. Outside the presence of the jury, unbeknownst to the members of the jury, the past paid amount, okay, comes into evidence, and then the past unpaid comes into evidence, and then it's subtracted, okay, and the difference is taken off of the overall verdict. So if the overall the past paid amount was $90,000, and the past billed amount was $90,000, and what was actually paid was $50,000, $40,000 is subtracted, okay? The jury doesn't know that. What happens with the past unpaid medicals, the plaintiff's bar is getting around the set-offs because you don't subtract something if it was never paid. It's still the IOU that's out there. And that it leads to the increased verdict, and there's no subtraction on the set-off from it. So the plaintiff's bar is using letters of protection to inflate the overall value of past medicals, and then they are getting around the set-off rule because it is an unpaid amount. So what we're advocating for is that jurors see the real number that was actually paid, and we're asking that we allow jurors to see that there are other numbers in this that's potentially out there, including the amount that the letter of protection was actually sold for, or what other charges are in the relevant geographic area. This is the reason why this is the biggest cost driver in a tort case, that these medicals artificially inflate the overall verdict. And my thesis is they artificially inflate the overall verdict by the value of the case tends to be 4 times that number. So if you ask me what is the most important thing that you could do on civil justice issues or lawsuit abuse, it's solving this issue and trying to get the real past medical number in front of the jury. And remember, this is all starting from a relationship with a physician that has been referred sometimes thousands of cases by a plaintiff's attorney that the jury has no idea of that relationship. And what occurs usually is a defendant has an independent medical examiner say, I want to see what you have, your injuries may have been in the past. Can we do an examination? That is not protected by attorney-client privilege because it's the defendant that has asked the plaintiff to see that IME doctor. So when that happens, there's a cross-examination that takes place, and it makes it look like the IME doctor hired by the defendant is in cahoots with the defendant because of that pre-existing relationship and payments, but that converse doesn't happen when the referral has been made from the of the plaintiff to the LOP doctor. So we need to have basically both sides treated fairly, overturn the Worley case, and allow real medicals to come into evidence. That, in my opinion, is the biggest cost driver that's out there. Now, Alix is going to talk about how that really affects real world, the trucking industry. And Alix?
Thanks. So I'm Alix Miller, President and CEO of the Florida Trucking Association. We represent about 415 companies, both statewide and nationally. And so I'm actually going to start. If you get bored of me talking, you can look and try to examine the damage of these two cars and make your own assumptions of what the medical bills are before. That's at the end. So at first, William makes a great point about the importance of transparency and damages and how it really affects a case overall. So what I wanted to do is pull it back a little bit, look at, say, the trucking industry holistically and really see how this affects the entire state of tort in the state and nationally. And the first story is going to be a recent settlement at Werner Enterprises, who is a FTA member. And this story begins actually in Texas. Early morning, I-30, 3 adults and 2 children are driving down the road. The 3 adults start getting into an argument. They stop the car in a travel lane, leave, go to the side of the road, and leave the 2 children in the car. A truck turning the corner, going under the speed limit, has no opportunity to avoid the car and hits the car, killing the 2 children. Law enforcement does not cite the truck or the driver, was put 0% at blame. The mother, the driver of the car, is being criminally prosecuted for manslaughter. What happens in this scenario for trucking? Werner Enterprises settles for $150 million. Because despite the fact of no fault, the entire system is set up in a way that they would be looking at an 8-figure settlement. Easy. The second story takes place just 20, 30 miles down the road in Quincy. There is a 45-vehicle pileup. A truck driving down the road sees the accident ahead of him, tries to evade and avoid hitting the cars in front of him. So he jackknifes and moves over to the emergency lane. So he is out of the lane of traffic. He does not put on his emergency flashers soon enough, so a motorcyclist behind him comes up and hits him. This motorcyclist does have some spinal injuries, not paralysis, some incontinence issues, and also a couple of manhood problems. So the settlement for this, with 45 cars, 45 vehicles, there's one deep pocket in this scenario, and the verdict came to the tune of $411 million. So why does that matter? Well, trucking is one of the major reasons why we now have the #1 worst state for nuclear verdicts. Just for trucking, when it comes to verdicts, between 2010 and 2018. In 2010, the average verdict for trucking was $2.3 million. 2018, it's $22.3 million. Social inflation has added $20 billion to verdicts across the country. There's a lot to do with the mentality of who trucking is, what they have, what they don't have, and we see it on the billboards every day, which I know we'll be coming to pretty soon. But just for the record, 97% of trucking companies are small businesses. So when William is giving these examples of $100,000 LOPs or medical bills, those quickly add up, particularly because when you're dealing with the unpaid and the paid medicals relating to the future medicals, that to us then translates to the punitive. So by giving that realistic, true, transparent number of a medical bill, we then can kind of mitigate that penalty that trucking always pays. So to begin with some of these examples, what usually happens with trucking is there there is obviously an incident on the road. It could be minor, it could be catastrophic. Trucking really, I'm very proud of the industry. It is committed to making people whole again. If they do something wrong, they will quickly pay, and happily pay. They take responsibility. But that's not really what's happening anymore in the court system. So what immediately happens is they got hit with a proposal for settlement. And remarkably, it is always that minimum amount of insurance. So I will say that that car, well, both of them, both of these incidents here immediately were offered to settle for $2 million each. And when there's a famous commercial on TV here in town, actually, where they say that even if the driver of a car is 90% at fault, don't worry, we can make 10% a windfall for you. So usually, what usually happens is the argument from trial attorneys is that, well, if the truck hadn't been there, this never would have happened. So that's worth at least 1%. Therefore, we're going to bring you to trial. So then we move to the medical damages, the crux of this complex process, which then informs, as I said, the punitive damages. So we're really stuck in the settlement mill because in the example of Werner, we're terrified as an industry for these verdicts because they are just simply out of control and in no way reflective of what's happening on the road. So this first one, for example, the red car, as I mentioned, a $2 million proposal for settlement. This was on the Hart Bridge. I believe that's in Jacksonville. I'm not a native Floridian, so sometimes I get these things wrong. This was a side scrape. This one does have cameras, although the camera in the truck to the side, it was not seen because the car was in the blind spot of the truck. The total repair cost for this red car was $2,800. The medical bills were $900,000. A lot of soft tissue damage with this one. So this one was quickly settled. The second one here is, I don't think we can zoom in here, but I did over the weekend. This was a truck, here we go. There's that little patch, but that's not from the accident. So we're talking about the hood. This is an incident where the hood was injured. The truck was reversing, so going about 1 to 2 miles per hour. Reversed, obviously the top of the trailer gets onto the hood of the car. There is no dent on the hood. Apparently there's a scratch. They sued for the scratch. Proposal for settlement, $2 million. One of our member companies said, you know what, enough is enough. We're not going to settle, we're going to fight this one. So they do. And 3 years later, they end up having to settle for $450,000 due to the medical damages of this scratch on the car. So everything is kind of stacked against companies when it comes to these issues. And transparency in damages is a significant it would, improve the climate of things to really change all of the other pieces when it comes to a tort case. I think we have a little time. Does anyone have any questions?
Thank you all very much for being here. Obviously, this is a problem we've been hearing about, especially from some of our members. Do you have an estimated cost that, over the last 5 years has been paid from these, expanded medical proposed damages? I mean, how much overage are we all paying?
Well, Brewster, let me take that one. And basically, what we're seeing is a factor of the real medicals being exaggerated 4, 5, 6-fold for each case. So let's look at the example that Alix gave of that silver car with the truck backing up and hitting them. That's a tort. The liability is there. The plaintiff's attorney now gets into how do I manufacture big damages on that fact pattern. If that injured person went to their legitimate doctor and used their already existing insurance, probably the medicals would have been somewhere about $10,000. But they are instead referred to a doctor that is in cahoots with the plaintiff's attorney, and then the medicals, through the use of a letter of protection, become $50,000. So I like to answer that question by, it's a factor in each case of 5, 6-fold greater than what it should be. So those examples that I gave you, the first one's in green, you can see what the real medicals should have been. That first one, they should have been $7,700, okay? Instead, the jury's seeing $80,000. The doctor is then selling the LOP immediately for $15,000. The factoring company, which is owned by another Brethren personal injury attorney, owns that paper. If that verdict then comes in at 4 times past medicals, because it is a tort, the truck did back up and hit them, I expect that verdict then to be $320,000. And then there's a negotiation with the plaintiff's attorney and the people that own the paper behind the scenes, and they won't make the plaintiff's attorney whole for the $80,000. They might give them $20,000. But the two of them have conspired together to create a 5-fold, 6-fold greater price verdict on a real tort case. So that's the real problem, in my opinion.
And what does it cost you? Yeah, so a lot. And obviously we have figures that range from $2,500 to $5,000 a year for a tort tax. There's a lot more to it with that, because I know for our trucking companies right now, the 10 biggest insurance companies have left Florida due to this. Our companies pay twice as much right now than they did a few years ago, but they only have half as much insurance. And they want insurance. They want to protect people. But what is more problematic for everyone is when we all talk about this inflation and expenses, the profit margin from a trucking perspective for what they do is very slim. It's roughly 6 cents on a dollar. If you add up these millions upon millions of cases and inflated lawsuits and payouts, no one thinks about or takes for granted the transportation of your goods. So every single thing that you eat, touch, wear, drive on, that price is increased because we have no choice but to cover the legal expenses for frivolous lawsuits onto the movement of goods.
So we hear from our members a lot, PG Murphy, FAI, Florida Association of Insurance Agents, we hear from our members a lot about the impacts that these issues have on the commercial auto market. As we look at other issues and other lines of insurance, we have kind of 2 competing issues, pricing and availability. What do your members from your association do? Obviously pricing, I hear about it probably 7 times a day. But do they have any issues with actually having the ability to acquire coverage?
To require coverage? To acquire? Oh, no, they can't. They're many small, I mentioned that statistic of most being small businesses. So many have gone out of business in the past couple of years because they simply can't afford that premium. A lot of have entered into captives with like-minded or safety-minded companies that reflect their values and kind of demographics. But it is incredibly difficult. The first question, you probably know, first question when you are a commercial motor vehicle company, the insurance asks you, do you run trucks in Florida? And that could be not even that you're based in Florida, but how many miles do trucks that you have run in the state of Florida? Because that will be whether or not A, they're even covered, or how much it's going to be.
Representative Smith?
William, can you, in your worksheet that you cited, I noticed several case law references throughout. Is the predicament we're in today because of the interpretation at those cases, or is it legislative? And so are we in the fix today because of the way courts have ruled, or because of what we have in current legislation?
We are in the problem we have today is was a series of bad case law from primarily the Florida Supreme Court up through 2019. Currently, we have probably the best appellate courts in the entire country, thanks to Governor Ron DeSantis and the appointments that he recently made. But there's bad case law that still exists out there that defendants have to operate under. So until that case law is changed, or until the legislature changes statute and allows those statutes to be litigated and then brought back up to the Supreme Court, the old case law will continue. So the Worley case that I gave you the example of, saying that that's attorney-client privilege, when it's actually at best medical privilege and shouldn't be protected by attorney-client privilege, that case came out in 2014. What we need is the legislature to change that law and right that wrong, and that's what we're looking, hopefully, that the legislature will probably do that. So the cases that I showed you as aberrant examples are coming under the umbrella of bad case law that existed and continue to exist through 2019. And if you're a circuit judge, if you're a trial judge, there's nothing you can do. You have to follow that case law until the Florida Supreme Court eventually changes it. So it may be many years in the future. So what we really need is the legislature to make statutory changes, and then circuit judges could follow the new statute, and so that's what we need to do. Sal?
I mean, if you're on the Florida Turnpike, you throw a rock and you hit 4 billboards with people, holding a check from an attorney, whatever. Those have, a messaging strategy to them. Is there any polling or messaging that can be used to push back, thinking through kind of the legislative strategy? Lawmakers are going to have to go back and, speak to constituents who are going to get messaged by trial attorneys saying, your representative is sided with big insurance companies, yada, yada. Are there messaging strategies or tactics that, have been proven effective?
It's tried, but what is going on with those billboards and with the ads that you see on TV, it's twofold. One, of course, they're trying to get business. But number two, they're trying to create a marker for future jurors as to what the value of a case is. So you're driving on the turnpike year after year, you're driving on the interstate, and you see these ads, a trucking case is worth $2.5 million. Dan Newland got me $818,000. And then you are asked to serve on a jury. In your mind, a verdict of $818,000, $2.5 million for a trucking accident is okay because it's been validated every time you drive on the interstate and every time that you see these commercials. So that's what is so difficult to overcome. The plaintiff's bar is putting out a value on all these cases with all these ads.
I think I would also add, I think there have been some missteps of, it's easy for the other side to pit trial attorneys versus insurance companies. And I'm hoping that will change. We'll wait and see for this legislative session, but you really need to focus on that third party, the industries that are being directly affected by it and why that affects the average Floridian or every Floridian. We've already seen with healthcare and assisted living and, those real world implications of what this is doing is far more compelling. And I think people can relate to it because, quite frankly, the problem is everyone thinks because of those billboards, these big, bad, giant trucking companies, right? But 90% of them, at least in Florida, have 3 trucks. It is mom and dad with their 3 trucks, and one side swipe puts them out of business. And they're in every community, and they're at your church, and they're at your T-ball team, and all of those things. So the humanizing of all of these different industries that are affected and how they affect every person in this state is what we really need to do.
Okay, thank you.